This meeting to order. We'll begin with the adoption of the agenda.
I'll make a motion to approve the agenda.
I'll second the motion.
Chairman Hayman.
Aye.
Vice Chair Peters.
Aye.
Director Vallejo.
Aye.
Director Griffin.
Aye.
Director Etnier.
Aye.
Motion carries.
Okay, moving to item number 3, public comment on closed session. Do we have any public comment on closed session from the floor? Seeing none, do we have any public comment from the phones? None? Okay, we will now move into closed session. Into open session, we'll begin with a report out on closed session.
Thank you, Chairman. There is no reportable action from closed session. The agency met on all of the items listed, but I understand that Director Griffith has something he'd like to say about closed session.
I do, thank you. After meeting, I feel that it's best that, as a member of this board, that I take to my board at our next meeting, I'm going to add it to the agenda, that I feel that we should enter into a mediation to where we can start working together and talk things out, because I'm just tired of the arguing, and I think that's the next step we need to take. So I'm going to be adding that. I believe we have a meeting on the 28th, 27th or 28th, I'm not sure, but I want to add that to our agenda so we can vote on that to enter into mediation.
Director Griffin, I commend you on that initiation and wish you success on it. Okay, next we will have the Pledge of Allegiance, so everybody will please stand, face the flag.
It's right there.
Our flag is on the table, so change position. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we'll have roll call.
Chairman Hayman.
Present.
Vice Chair Peters. Director Griffin.
Present.
Director Etnier.
Present.
Director Vallejo.
Present.
Okay, moving to item number 6, public comment. This time is reserved for the public to address the board about matters not on the agenda. No action will be taken on non-agenda items unless authorized by law. Comments are limited to 3 minutes per person. And do we have any public comment from the floor?
Judy Decker. I would like to thank Supervisor Peters for his attempt to get his fellow supervisors to support both AB 1413 and AB 1466. All the domestic well owners in this valley, if they all knew about it, would thank you also. Thank you.
Thank you, Judy. Do we have any public comment on the phones? Seeing none, we'll now move to item number 7, board member comments. Any board members have any comments they wish to address or say? Okay. Moving on to item number 8, consent agenda. This will consist of items 8A, B, B1, 2, 3, 4, 5, and 6. Does any member of the floor wish to have any item pulled?
Director, I would like to not have an item pulled. I just want to make a statement. I know this is a routine budget and we have to pay the bills that are approved, but I want to go on record as stating that as a representative of this board, I do not feel, by approving this, I'm not authorizing Capitol Corps to pursue and continue to fight for legislation on AB 1466 and 1413.
Any member of the board wish to have any item pulled?
I'll move for approval.
I'll second.
Chairman Hayman.
Aye.
Vice Chair Peters.
Aye.
Director Griffin,
Aye.
Director Itnire,
Aye.
Director Vallejo.
Aye.
Motion carries.
Okay, moving to item number 9, board consideration of resolution 01-25, establishing a second transient pool. This will be with Phil Hall.
Thank you, Chairman. As we've all known, we've been talking about the second transient pool for, I think, well, this would be 6 months now. This resolution finalizes and formalizes that. The operative sections of this resolution, in large part, have been already sent to the small farmers dating back 3 months ago, I believe, is when we first sent it to them. We've had one Zoom meeting with them over it, and then a month ago, I sent them the final, what I believed was the final draft version, which is essentially what you have here now for the operational section. I have not heard any comments or concerns from the small farmer community about how this will work. I could go over some of the terms if you want, but I think they're pretty straightforward, and you know, there's a pricing scale, there's 4,000 acre feet. Small farmers are able to ask to be a part of that, and then we'll divvy out that 4,000 acre foot based on how many we get back per acre. I do want to say one thing about this. If somebody has concerns about the recitals and why the recitals aren't just to the project, what this transient pool is, they should understand that we need to establish a record at the GA as to why we believe import water is needed, what historical factors we've had to show that, why we still believe it's needed after we adopted the GSP, and how we think we have enough of a transition period to assist and to provide more, how shall we say, lack of shock from changing the status quo. You know, we've got to temper changing the status quo. We have small farmers in this community that will no longer be farming after we get to sustainability. That's what this is about. The recitals, I believe in the staff report, I make clear, yes, the water district has done things in the past, but that's the past water district. It should not be, what happened 30 years ago should not be impugned on what Chuck is doing at the water district now. It is just for historical reference. So I think we should make that clear. Other than that, if you have any questions, I'm free to answer.
Any members of the board have any questions or comments?
I have a comment. Seeing this on the agenda, I was going to abstain because I was not involved in the settlement agreement with Mojave Pistachios, and I know that's what this relates to. But I'm very troubled by what I feel is the slander of the water district in the recitals. What the recitals have nothing to do with, in my opinion, the settlement or how it was reached or approached. This is, it's 20 whereases of why the water district's at fault, and we're not coming at the county at why they could be at fault, or the city, or every other farmer, or every other person in this valley. It's at the water district, and I feel that it is comments that are unneeded. A lot I feel are untrue, and I just don't appreciate those being in there. So I will be voting on it today for that reason, because I cannot support it with these remarks being made about the water district. This is why I will ask for the mediation, because the slander needs to stop on both sides. We need to move forward. We need to work together, and this does not accomplish that.
So I guess I should respond again. I don't believe anything in this is infactual. For example, in 1995, the water district looked at the water district at that time. You weren't on it 30 years ago. I mean, I hadn't even gone to college yet. I guess I was in junior college. But 30 years ago, the water district and others in this valley come to the conclusion that there was a water problem. That provides historical background to the GA making that same choice now. And since this GA has experienced individuals, some of with ties to the water district, that have said, we came to the conclusion imported water up here at the GA, that was our conclusion. that nobody else had ever considered it. This provides historic background. And as I just said and tried to preface all of this, your board today is not a board from 30 years ago. The Water District is an entity that has different board members on it. And you might disagree with what went on in 1995. And you might disagree with your Brown and Caldwell report from 2009, which showed the sustainable yield wasn't enough for this basin, domestic use. And I appreciate that you might have those choices, and that's why I've put together a staff report trying to say this is not about your current board. But we do need to provide a record, and the record needs to show the history, and that the history is the prologue to what has gone on here. And this GA is reflecting of that and saying, look, for 30 years, nobody's been able to cure this problem. We have what we believe is a solution. That solution is going to change the status quo in this basin. And we need to address that. Now, part of changing that solution is an import project that we now look to have a lot of funding for. We're in a good position on funding, would you not say? And if that's the case, then we can be a little bit more open with the use of the storage. And this is 20% more storage to be used to help those that are going to be greatly affected by what happens with sustainability.
Okay, I appreciate your comments, but still, in the first transient pool, when you were trying to establish the same thing that you're doing right now with this transient pool is reflective to a settlement agreement that was reached because somebody did not pay a replenishment fee. So you reached a settlement, you issued a new transient pool to allow more pumping of water, and it does not need to include all of this history on the water district that you feel is what caused the issue. So, because this has nothing to do with the pipeline project. So if you're arguing on the pipeline project, then I could see you adding this in there. If you were defending that and why we wanted to build a pipeline, what we wanted to do, if you had that in there, I could understand that. But all of this has nothing to do with the transient pool, allowing more water to be pooled at a rate. So that is my only issue. And I'm not going to argue with you anymore.
Yeah,
I just want to tell you that that's my feelings.
And I appreciate that, and I should have brought this up because you mentioned it the first time too. You're confusing why we have the second transient pool. The second transient pool and the ability to go into the second transient pool is what allowed us to come to a settlement with Mojave. It wasn't a settlement with Mojave that drove the pool. This is a policy choice based on us being able to get funding. Because you recall, this all occurred at the time that the word of funding came in. And so this is a policy choice. It benefited Mojave in being able to settle with us, but this is not because we settled with Mojave. Mojave doesn't need a smaller portion for small farmers out there. That is this board, and you weren't involved in some of the discussions at that point because of the conflicts with the litigation, but this is a policy choice that helped Mojave. This isn't driven by Mojave.
I understand that.
So with that in mind, we have to establish the history in this as to why we need import water and what the safety valve came in with the funding that allowed us to move forward. You're thinking this is a settlement puts this together. That is not what this is. This is a policy choice.
Well, I would just like to see that first part removed, but that's up to my other board of directors. I don't feel it's appropriate or necessary to slander the district that way. I have no more comments.
Any other comments from the board? Any public comments from the floor?
Judy Decker again. My comments are many, actually. If the staff and the Water District directors would go back in time and read what should be available in the library at the Water District and other places, they would find that the community, that is the scientific community, decided that something needed to be explored, and we were offered by the Bureau of Reclamation money for a study. It was the first study that really opened the doors wide for everyone, and that is the Bureau of Reclamation Indian Wells Valley Water Study, which drilled half a dozen or more wells to a depth of 2,000 feet. It was the first time that had been done. Each of those wells were e-logged. Each of those wells have multiple piezometers that are read on a regular basis. What that showed is that there is not much recharge in the Sierras. That led to further studies by the Navy, who drilled 2 or 3 wells to bedrock and on to other studies. Board of directors, when they are elected, need to do their homework, and that means going back in time. What Phil has in his document is not slandering the water district. It is stating what happened. I was part of that during the times when I was on the board. And I will remind all of you that in 1985, I ran for water district the first time on the basis that we were in critical overdraft and needed to do something about it. The problem is that the something about it was never achieved until Sigma came along and forced the issue. And no, I don't like the transient pool and the additional 20,000 acre feet of additional water to be pumped. I think that some of that ought to be offered to the small well owners because they are the ones who will be directly affected. Thank you.
Thank you, Judy.
Wes Katzenstein, member of the PAC and domestic well owner. First of all, I want to thank all the hard work that's led to this agreement with Mojave and others. I have a couple of points I made early from here is I see, looking forward, I think it's important that this agreement not be guaranteeing to Mojave or any other farmer that there will be water. We believe there will be, but we do not want to be guaranteeing that there will be this pool. We do not want to guarantee that the quality of this water will remain to be good. There's a lot of bad water out there, I think, as everybody knows. And in a way, I think we want to be sure that we're not, that we continue to have protections for shallow well owners out there. If a lot of wells start going dry or going bad because of change in water quality, we need to know that we have not given up the ability to take recourse to protect those shallow wells. So that's just my concern as we move forward. I want to be sure that we're not guaranteeing that there will be water to Mojave, that we're not guaranteeing that that will be quality water, and we're in no way releasing our need and perhaps Mojave's need to protect shallow well owners should it be needed. Thank you very much for your work. And I like really the way we're moving forward. I like the legislation that's been proposed. I think that's what the state of California needs for all adjudications, for all SGMA-related activities. We need to know how adjudications relate to SGMA. And I think maybe we'll be talking about this a little later. I have a couple other brief comments when that time comes. Thank you, everybody, for their efforts.
Thank you, Wes. Okay, we'll move to the phones for public comment. Caller, go ahead. Caller, go ahead.
Good morning. My name is Darian Keith from Fenimore LLC, speaking today on behalf of our plant, Meadowbrook Dairy. I'd like to raise two distinct issues regarding this item. One, the lack of further process on this item to date, and two, the lack of analysis on how this policy comports with SGMA. First, the GA has had months since first referencing a second transient pool in December 2024 to explain this policy, yet it waited for 48 hours before this meeting to release the resolution, and then less than 24 hours for a staff report. Between December and now, there was no staff report, no draft policies, public workshops, or outreach to all stakeholders. Key information has only been shared through verbal remarks at the board meetings, with no written policy. leaving the public and interested participants without a meaningful chance to understand or comment on the program. GA Council has requested feedback from select few pumpers based on the incomplete resolution languages, but as opposed to the community as a whole. This lack of transparency and stakeholder engagement is troubling for a policy that could affect basin management. Second, there's not been an explanation or analysis for how this second transient pool is permissible without a GSP amendment. California Department of Water Resources guidance on GSP amendments clearly states, and I quote, elements of the GSP that may warrant a plan amendment if significant or material changes were made include revisions made to projects and management actions, including addition or removal of project or management actions, end quote. A program allocating 20,000 acre-feet of groundwater with 16,000 to one entity appears to be a material change. Yet there's been no technical analysis or public review to date. The only justification so far is that it was sufficiently covered. That is not adequate under SGMA or DWR guidance. Meadowbrook requests that the board delay action on this to allow at least 30 days for public comment period. Additionally, it asks that all relevant documentation and analysis regarding the transient pool be released during this comment period so that the public as a whole can review it. Thank you for your attention and commitment to a transparent process for this and all the members of this basin. Thank you.
Thank you, sir. Any other public comment from the phones? Okay, seeing none, we'll bring it back to the board for any other comments or motion.
I have one question just for clarification. Mr. Katzenstein brought up is there a guarantee in this of water, or is it as available?
This is essentially guaranteed water.
Okay.
We are unaware of any reason why it would not be something that they could take out. If something happens drastically, I mean, the GSP says this is available water, put it that way. If something drastically happened, we could reevaluate where we were at that position. But this is not a large chunk of water. Remember, there's really already two transient pools. There's what we call transient pool 1. And then there was how much is going to be overdrafted by Cyril's in the water district before they got into import water. This is 20% of that value. So, you know, at some point in time, we have to recognize that the domestic use is still overdrafting also. And if something happened, we'd have to figure out a way to minimize that impact over both. So, yes, this is guaranteed, but guarantees aren't always what guarantees are. Something could happen for us to modify and go into an emergency mode, but I think we're safe at this point. In fact, I wouldn't be surprised if in some future realm there might be a request for a third transient pool because we have gotten the pipeline even further into construction and our safety valve is there.
Understood. I appreciate it. Okay, with that, I'll make a motion to approve.
I'll second.
Chairman Hayman.
Did-
There was a second, Vallejo. It was very quiet.
Aye.
Vice Chair Peters.
Aye.
Director Griffin.
No.
Director Itnyer.
Aye.
Director Vallejo.
Aye.
Okay, moving on to item number 10, legislative update. I believe that will be with Capital Corps and I believe Mike, but
Good morning, members of the board. Yes, this is Michael McKinney. In your packet is a full report of two pieces of legislation that are pending before the California Assembly at this moment in time. To give you an idea of where they came from, essentially what has been happening since the adjudications have been filed in multiple basins is that the State Water Resources Control Board and DWR have become aware, as have all of the basins involved in those adjudications, of how the current adjudications impact SGMA implementation. We being the Groundwater Authority, put together a legislative proposal in response to that. The outgrowth of the legislative proposal are these two bills. So they are completely actually different than what our legislative proposal language is, but they were agreed to by various parties within the state legislature and within the agencies. Adjudications essentially impact SGMA in three major areas. One, the ability of a groundwater authority or any agency to finance particular infrastructure projects or the purchases of water within sustainability measures. To the ability to create or initiate competing or conflicting water management plans within a basin. And three, and probably the most concerning to the state, is the delay of the sustainability measures through an adjudication, which basically allows for continued and uncontrolled overdraft within that basin. There are some statistics here in front of you regarding what is going on with the various basins within the state, what DWR is doing at this particular point. There are 5 active adjudications at this point. 4 of them are in critically overdrafted basins, 1 in a heavily overdrafted, and then there has been a 6th one that has been settled. Essentially, 23% of the approved GSPs by DWR have resulted in an adjudication. The 2 bills to help deal with the impacts of adjudications on SGMA are Assembly Bill 1413 by Chair Pappen. That bill is pending. In fact, it may be out of the Assembly Committee on Appropriations as we speak. It has passed the Assembly Committee on Judiciary and passed the Assembly Committee on Water, Parks, and Wildlife. It essentially creates a system that allows for an adjudication to continue forward while rectifying or reconciling many of the problems between a groundwater adjudication and SGMA. There are 2 state laws that are driving this. One is in the Code of Civil Procedure, Section 850B, and the other one in the Water Code, which says that the court cannot substantially impair the ability of a groundwater sustainability agency, the State Water Resources Control Board, or the department to comply. Courts in 2 of the 3, two of the 5 are asked the question directly, how do you want me to reconcile these 2 pieces of the statute with what is going on and what is being asked of the court in the adjudication. And so far, we do not have a clear path in both cases, and that is ours and Kiama, have resulted in the judge saying, I wish that the law had been written more clearly. 1413 is going directly to that clarity and dealing with that. There are several opposition arguments against that. The opposition arguments are there in your packet. Essentially, they are arguing that the ability to challenge GSP through the adjudication process is removing the right to properly adjudicate a water right within a groundwater basin. Here, it is not dealing with the adjudication of the groundwater right. It is dealing with the process and procedure that the court is following. So how the court goes about looking at a, say, field trial. What standard of review does the court use? What are the triggers in that? It does not impact the final determination or the ability of the court to come out and say, here's the size of the pie, and here's how it's going to be divvied up. The other part is that they are arguing that the validation process is insufficient to satisfy the ability of the parties to challenge the GSP. We frankly disagree with this. We believe the parties have adequate legal redress through what is a validation action established within the Sustainable Groundwater Management Act that is specifically for the purpose of challenging a GSP. And then they further claim that the validation fails to properly protect due process interests and water rights holders. This is going to be something that the legislature is going to have to debate where it's going to draw the line on what it believes are due process procedures. The issue at hand for the legislature is SGMA put together a local process with public stakeholder input, based upon scientific input, that is then done in public and has to be approved, and then is overseen by the state. And so there are multiple areas in the SIGMA process to allow for due process of comments. And so the legislature is going to have to decide whether or not those were sufficient due process requirements to move forward, or whether they believe that additional due process requirements are required. AB 1466 is pending on the Assembly floor. It has passed the Appropriations Committee, the Judiciary Committee, and the Water, Parks, and Wildlife Committee. This establishes a standard of review for the GSP at substantial evidence. And then the second thing that it does is it allows the courts to request a report to address small farmer and disadvantaged community members' needs. Two things are happening here where the legislature is being asked to review and determine a public policy on. As I previously stated, there is a SIGMA process. That SIGMA process has had over $1 billion of state investment put into it. What litigants in our adjudications are asking for is what we call a de novo review.
Then I'm meeting through lunch. Probably right after lunch, I'll give you a call.
Mr. Helsley, I can hear you.
All right. Thank you, Charles.
They're asking for a de novo review. That de novo review is essentially, to put it in layman's terms, starting from scratch, throw it out as if the process did not exist and start over. Utilizing the substantial evidence review standard, the local and safe state approved process is not a set aside, but is used as a starting point for the court discussions. The second area that 1466 is dealing with is there is a provision in section 850 of the Code of Civil Procedure which requires the court to consider the water use and accessibility of waters for small farmers and disadvantaged community members. This is a subset of what we know as de minimis well owners. And what this does is establish a possibility of how the court will hear that evidence in order to consider. What is going on in the current adjudications, all 5 active adjudications, is that small well owners are being defaulted out. If they do not appear in court on their own, they cannot present evidence in support of their water right to the court. That is essentially what is going on. That is the net effect of what has happened. And in our opinion, the court has the requirement to consider their water right within its final action. It needs to have a mechanism in order to hear the evidence for that consideration, or it cannot properly meet Section 850 of the Code of Civil Procedure. Opponents' arguments is that complete de novo review is required to meet the due process standard. We do not agree with that. And then they also are arguing that all parties must be present in adjudication to present court evidence in support of their water rights. Historically, I want to say that de minimis extractors of groundwater were exempt from adjudications. It has been more recently that this troubling ability to default has come away from that. To put it another way, opponents have basically stated that this actually was a statement in Kern County that it is their right to take away the water rights of those that cannot or do not participate in the adjudication. On this particular issue, we believe that forwards and advances the pay-to-play aspects of the groundwater litigation and basically forces a determination of winners and losers, and we oppose that. The other argument is that the report is outside of the ability of the GSA. Our GSA includes an entire section on de minimis well owners. All of the information that would be required for the report is in there at this particular time. It is supported by Fox Canyon Groundwater Management Agency, supported by the city of Ridgecrest. Other local governments are looking at it. Several environmental groups are looking at it as well and are in support. And today I just received the East Kern Resource, East Kern County Resource Conservation.
We lost you, Mike.
Members, did I lose you?
Mike, yes, we lost you. You ended at the, where you were making a comment about you had just received the East Kern Conservation something.
I think he's pretty close to being done. We've just got a couple more support letters coming in.
Apologize, board members, I lost connection. I am back.
Okay, we can hear you, Mike, and you had left off with the, your comment about you just received something from the East Kern.
In support, East Kern County Resource Conservation District, both in support of AB 1413 and 1466. And from there, I'll answer questions.
Okay, we'll bring it back to the board for any questions for Mike?
I have a few. Mike had said at the onset of his presentation that the Groundwater Authority Board or staff helped author this. I just wanted to know from Mike, where did that authorization come from? I never voted on that, so I didn't know if other board members had in closed session or where that was at. I was curious, as I am in opposition of these two bills because I believe that they take away the right for the public to challenge. It's almost as you're guilty until proven innocent. It doesn't allow any challenge. It takes people's rights away. So that is my main objection. I know that the Water District could support this bill with amendments, and we've sent amendments, and some of those amendments include, as Michael mentioned, the de minimis user, exempting the de minimis user from the adjudication to where they would not even be involved, and the Water District would support that, and that's what we sent in an amendment. So I know that from Mr. McKinney stating that this was funded, and I've seen the invoices, and we spent almost $40,000 in the last 3 months on this bill and addressing Congress and our Senate and everything we've done. So I just want to get an answer to that so I'm clear on where that's at, because I've had people ask me, did you vote? No, I did not vote. So I don't know where this came from, who said, okay, let's do this, let's pursue this avenue. I just think it takes if this bill is passed as written, it takes the right away from anybody in a basin managed by SGMA to ever challenge what that groundwater authority establishes as their recharge rate or their sustainable yield or anything.
Chairman, if I may.
May I?
Let me handle some of it, Michael. So let's be clear. This bill in no way, shape, or form stops anybody from challenging a GSA.
Through a court, it does.
No, it does not. You do not understand how litigation works. Let's walk through this. And let's now go to the next step. How did we get here? Everybody in 2014 thought this was the law, and that you challenged sustainable yield and the GSP in a validation and a writ process. You don't sue everybody else in the basin so that you can challenge one part of a GSP, which is what the Water District chose to do. Instead, you sue the agency that you're upset with. That's what you do. You chose not to do that. That's your choice. You, the Water District, chose to sue everybody in the basin. You have a process. You're acting as though there's no process. There is absolutely a process. Now let's go to the next step. As you know, this has been an issue because your adjudication lawsuit has been trying to do this. And again, to turn this adjudication into an attack on the sustainable yield adopted in the GSP that your district voted for. Here's the concern. You have the state of California through the Department of Justice saying prior Sigma law, in an amicus brief, is what this bill says. You don't like our sustainable yield, you challenge us. You don't sue the Deckers, you don't sue the de minimis well owners, you don't sue small farmers, you challenge us. And we could have already had the validation action and it would have already been over. But instead, you're now sitting, as we speak right now, we have an admiral in a courtroom in Orange County having to defend the Navy's Federal Reserve right because the Water District decided not to challenge this GSA and not to challenge the determinations of this GSA. Determinations the Water District voted for. That's what's occurring. You chose a different path that sued everybody. This does not change that you still have the ability to go out and sue. What you don't have is the ability to drag everybody else in, take people that cannot afford to be part of your litigation, and strip their water rights away. Because that is what happens. So let's go to the next step. I don't know what amendment you have supposedly implemented or tried to put out there, but there is already in the adjudication statutes an amendment to remove de minimis well owners from an adjudication. The problem is you have to determine that the de minimis use is not material to the basin. In the groundwater adjudication statutes, that is 5 acre-foot or less. In Sigma, it's 2 acre-foot or less. We have tried to get those de minimis users removed from your adjudication, and your attorney said, quote unquote, we will seek defaults if they don't show up. That's what he has done. I shouldn't say quote, I'm paraphrasing, but that is it. He has said to the court very clearly, we will default them if they're not there. That also means to small farmers. So if Pat Quist cannot afford an attorney to be involved in the adjudication, she is going to be defaulted. Now, interestingly, we use the word default. Western Growers, which is one of your lobbying partners, has said it differently in their letters to the state legislature. They've said, you don't need to talk about default in your litigation, or excuse me, in your legislation. Default isn't needed. The fact that you do not show up at all means you don't get a water right, because it's an in rem proceeding and you have a duty to show up and participate. And if you can't, you lose. That's your lobbying partner, Western Growers. That's what they've said. Very clearly, I'll provide you the letter. So I don't know what your amendment says, but we have a problem here. Your attorney has acknowledged that de minimis users in this basin are material. There's no way they're not. At any sustainable yield value you can put out there, whether you use ours or the Water District's proposed value, whichever one of the, I think, 3 different values we've heard now, it's going to be material. So you can't pull them out. We tried to get them class counsel, we the GA. We were opposed by Searles Valley Mineral and the Water District and the local Realtors Association. I'm not sure why it was so controversial for them to have counsel to argue for their rights in this adjudication that you're putting forward, where if they don't show up, they lose their rights. But that's what happened. And your attorney was very clearly arguing against giving them class counsel. So now I'm hearing you want to amend these bills to remove them from the adjudication when it's already in the bills. If they're not material, they're removed. So all your attorney has to do is go into court tomorrow and file a brief that says, I want them removed because they're not material. Or I want to provide them class counsel. Or you could have filed a validation action and never brought them in. You're here taking the position that this strips you of the ability to challenge the GSP. It absolutely does not. What it says is, you don't like our choices at the GA, you sue the GA. You don't sue somebody else. especially somebody that you know can't defend themselves because they can't afford it, and then take away their water rights. That's the problem. And that's the problem that these bills cure. And taking this even further, I want to again point out, the Department of Justice, on behalf of the State Board and DWR, filed an amicus brief saying that is the current law as written in Sigma. Now, you've asked, when did this start? When did this process? We have closed sessions related to the litigation that you're not involved in because you're on the other side suing the GA. At times you've said you're not suing the GA, but it's very clear what you're doing in the adjudication is trying to overturn the GSP. Initially, the Water District's position was you were going to get together with other pumpers, the 5 large pumpers, say that you had 80% of the pumping in the basin covered, and therefore were able to force a settlement on everybody else. What you failed to consider in that was the provision you were wanting to force a settlement on also required you to have 75% of the pumpers in the basin, and you couldn't meet that. So that plan failed. But here we are today with an adjudication going on that, as I look at it, you have 6,000 to 7,000 residents in this community have zero representation in that, can't afford to have representation at it. Their water rights are in jeopardy because an adjudication was filed rather than a validation action or a writ challenging what we did. If you truly believe this is about challenging the GSA, I suggest you consider dropping your adjudication and filing a lawsuit against the GA.
I'd also like to address the public participation aspects that you mentioned, Director Griffin. Sigma is a public process. It's required in Sigma. The GSA is a public entity with all of its records available. The GSP required a public hearing. Comments that were made to the GSA had to be included in its submission to DWR. DWR then publishes that and opens it up for comments and questions and presentation of alternative evidence. That is a public process. Moving this to a courtroom 160 miles away from the city of Ridgecrest and putting it behind closed doors to only those who can pay to participate is not a public process, sir.
Okay, well, I appreciate your comments. I do want to make one statement. The Water District, as a board, I can guarantee you, has no interest in taking the rights away from de minimis users. So,
I can't let that go.
well, that's the truth. So-
Chairman, I can't let that go. If you're not interested, step up, support the GA's request to give them class counsel, and let's move. Or get them removed. But if you remove the de minimis users, you're going to have some small farmers out here that can't afford, so they're in jeopardy. So it's one or the other. You have the ability to direct your attorney to file either of those motions. Please do so.
I'm sorry.
We've had this discussion before.
I have to object as well. The lobbying partners in the opposition against AB 1466 have specifically stated that if people don't show up, that they are defaulted out. And it is their right to take those people's water rights. And I'm sorry, Director, it is your lobbyist sitting next to them. So you are in that room and tacitly agreeing with them, whether you want to be or not. And you have not stated a different position as the Water District, period. So your actions do not meet what you're saying on that dais.
Okay, I will bring that to our board.
Any other comments from the board?
Nope, I would just like to thank Mr. McKinney and all of our team for their hard work on this and their efforts to ensure that everybody's included, and this is a transparent and open process, and I appreciate your efforts.
Agreed. I just want to say that in hearing these comments, that it just reassures the necessity of these two bills. They address the issues of the small farmers and the de minimis users, and that they aren't stripped of their water rights. It addresses the issue of the ability to challenge. It's not taken away. It just puts parameters that it's done in a timelier basis, and that, like the council was saying, that, you bring it to the GA, sue the GA, and that goes to the courts. That's not handled by the GA. That will go to the courts. That will be decided in the courts, and decisions can be made that then both parties can continue to move forward. We have Sigma on the left side saying, we have to have this sustainability plan, and we have to be working within the parameters of managing these basins, which has been given to us as a local directive. I think that's the proper way to go. And we need to be able to continue that process of managing the basin. We can't do that when we're being stalled and taken down a lengthy road of money cost to the citizens that are paying it twice over. We can't continue to get funding. It stalls the whole process when a entity decides they want to, instead of filing that lawsuit, go through an adjudication and get to their same endpoint, but do it in a manner that's kind of backdoored and ends up costing everybody a tremendous amount of money. These bills, when you look at them, I can't see why anyone would oppose them on either side, because it just brings a clarity and a time frame to operate in that benefits both sides. And I think everybody should sit down, read this. The community should listen to what was just stated today, because it doesn't get any clearer than what has been presented. And I, again, can't understand other than, well, I do understand. I'm not going to say I don't understand why the opposition is opposing it. I do know why they are opposing it. It's not in the benefit of this community, I can tell you that. And so I urge everyone to educate yourself on what these two bills do, and try to reconcile yourself with the reasoning behind why it is beneficial. And we're here because of some of the actions that were taken prior over these last several years. And it's not good for the community. And I can tell you right now, I don't like the cost of it. I don't like how much it's costing the citizens of this valley. Again, we're being charged 2 times over. We're being, to fund the legal aspects of it as ratepayers, to fund it as the GA to manage it locally in our basin. So appreciate the comments that have been brought up today. And I'll end my.
Could I just make one more comment? And I just want to specifically address Director Griffin. I respect you, and I think you have a good heart and you care a lot about the community, but I don't think personally that you're getting accurate information about this. I just really would urge you to listen to the differing points that you've heard today and consider them, because this really is beneficial to the community as a whole. And there are a lot of interests, like Director Hammond said, maybe on the other side, that I understand why they would be in opposition to this. But, no offense intended to our council up here, but asking a lot of the lawyers on the other side if they support this is like asking a barber if you need a haircut. It's pretty evident that they're going to say that this is why we should oppose it. So I just really would urge you to dig down into this and try and understand from our point of view, from the community's point of view, why this would be beneficial.
Yeah. And I appreciate those comments, and I assure you that I am researching this, I'm studying, I'm reading, but I hope you'll do the same, the both of you, and we can come to an understanding, because I think we're both getting misfed information. Like you said, no offense to the attorneys, but attorneys are for each side, so I hope that we can decipher this and come to a true solution.
Speaking for attorneys, yeah, attorneys are out there getting paid by the hour. I unfortunately am not one of those. I have a specific salary, and it doesn't matter if I spend 15 hours tonight working for this valley or 5, I'm getting paid the same. So, but yes, it's a very, very good point. I mean, part of what's going on with these bills is adjudications throughout the state are going to bring in large sums of money to law firms.
So I just want to add, if the prior process of managing water worked in adjudications and the way it's been done in the past worked, then why are we here today?
Amen.
Because it's not working. California is not working in the past measures that have been utilized. Okay, any other comments from the board? Any public comment from the floor? I'll just reiterate, this is not an action item today, but welcome any comments.
Yes, I have several. First, I'd like to continue what I started a few minutes ago. If the water district, when I got on the board back in 1986, had done what I suggested, which was to contact the leaders, including the U.S. Navy, and discuss the issue of importing water and how to stop the overdraft or lessen it, we would have an imported pipeline project of some sort at this point in time and be receiving water. But that never happened. It doesn't seem to matter who's on the board, who's the manager, who's the attorney. The water district has steadfastly, over the last 40 years, refused to seriously examine the issue of overdraft in imported water. And it not only jeopardizes the citizens of Ridgecrest who receive their water from the water district, it jeopardizes the 1,000 small well owners that are here, the farmers that are here that shouldn't be here because we shouldn't have large-scale farming in this valley for the simple reason we don't have the water to support it, and we never have had. We have in our possession personal documents from a gentleman's family that was going to start a large development in Inyokern 120 years ago. That is where the first report on water came from Charles Lee in 1910 or whenever it was, that said there was not enough water to support large agriculture. This group of people had enough foresight to say, okay, where do we get it? They went to the state commission at the time to try to get water not from Inyo County, but from Mono County. They were denied, but a month or so later, the same request came from the Department of Water and Power in Los Angeles, and their proposal was accepted. So the water district has often said recently they're going to get water out of the DWP aqueduct. You're dreaming. I'm glad to hear, Chuck, that you want to actually get together with the rest of the directors here and try to work together. But you're going to have to get the rest of your board on board to do that. And I too would like to thank Mr. McKinney. I think he and his firm are a jewel, and I hope that the GA never lets them go.
Thank you, ma'am.
Good afternoon, Board. George Kroll, General Manager of the Water District. I want to try to speak to this in a little bit of plain English, how these bills factor in from a water district perspective. In general, yes, the fight is over the solution to the valley. Whether that pipeline is affordable to our customers is of utmost importance to the water district. And whether that pipeline gets built and those costs are passed along to our customers is what we're worried about. How do these bills play into that? 1413 in particular says, in an adjudication, you can be wrong as a groundwater authority. You can estimate that the sustainable yield is too high. And you can challenge and say it can be lower, but it specifically says, in an adjudication, you can't say that you, as a board, your estimate of what that is cannot be challenged. We can't say, oh, it could be higher. What does that mean? That means if the bills pass, 7650 will stick. What does that mean? That means that the pipeline will be built in all likelihood, unless something dramatic happens to change that. And that means our customers and the people of Ridgecrest will be paying the tremendous cost. And, to the point, I hear a lot of comments that are sort of centered around like, well, everybody else can afford water. The economic analysis that needs to be done, and I think one of the reasons we want to talk about, going into mediation is to really focus on those costs and nail them down and make sure we look at all the alternatives. Thank you very much.
Board, if I may respond, it specifically says that if you are going to challenge the sustainable yield at 7650, you do so through a validation action, and that once a validation or reverse validation action has occurred within the court, that in an adjudication, it sets it at whatever the sustainable yield. That takes care of the very first section and problem where we are having conflict, and that is the ability to finance any of the projects. What was just told to you is that through an adjudication, not through the validation process, they want to withhold the ability to allow the board to finance the pipeline.
If I may add one other thing, Chairman.
Yep.
Again, sue in the validation action, sue the entity you're upset with, not everybody. The water district spent, if I understand what they've spent so far on just serving everybody in their lawsuit, was $500,000. Rather than spending less than $1,000 to sue the GA, they spent $500,000 just to send letters to everybody in the basin saying, hi, we're the water district and we're suing you. And if you can't show up, you don't get no water. That's what has occurred here. These bills stop that. They say if you don't like it, you sue the GA. And then from there, if you still want to pursue a Federal Reserve right phase and you want to pursue prescription phases, you can do so. But the first phase of that is a validation phase to determine what the sustainable yield is and if the agency was right. And let's also consider something. There is no public agency in the state of California that is going to set the sustainable yield at anything lower than they reasonably think they can get away with. They're elected officials. The whole comment we're hearing right now is one elected official representing one agency, so let's say 5, is against 20 other elected officials, depending on how you want to do the math, and their view of what the sustainable yield is. The whole concept here is you're trying to argue that elected officials sat on this dais and picked a sustainable yield that was artificially low for some reason. It's nonsensical. And you know it's nonsensical because you voted for the sustainable yield. So I just want to keep this in mind. You can hear about, well, one version of the trial, another version of a trial, one judicial proceeding, another. One involved the water district spending $500,000 to sue everybody in this basin, and the other does not. That seems to be a no-brainer, but maybe I'm just a dumb attorney who is trying to keep myself from getting fees in the future because I work on salary. I don't know. I don't understand it.
Well, if I could jump in there, that is what I was confused by in those comments. And what possible way would it behoove an agency to artificially set a number lower than they believe it? I mean, if we want to talk about plain English, okay, we can't argue that it's higher, but we can argue if it's lower. Well, if I am setting a budget, I would estimate how much money I have available, and yeah, I'm gonna go with the safer route, and if anything, we're gonna err on the side of caution and say that we have less than that maybe in an argument, but I'm not gonna artificially just assume that I have way more money. That's how you get in trouble. And there's no reason for us as an agency, as community members, as anybody, to artificially set the number lower than we need to. That's just a bizarre argument to make.
Wes Katzenstein, a domestic well owner, member of the PAC. Just a couple of brief comments. First of all, once again, I want to thank everybody that's working so hard to seemingly solve this logjam in California law. And just a comment, I made this at the Historical Society when the Water District presented their study about recharge. I think the first priority of the Water District is to be sure they have water for the citizens of Ridgecrest in the future. I think there will be a water market. The price of water will happen. And we need to be sure we're in that game, and the first priority should be to ensure there is water. And just from my point of view, a couple of brief questions that talked about being sure that small farmers are represented and disadvantaged small pumpers were represented. I don't know if those two classifications really includes the shallow well owners in this valley, in the sense they're not necessarily poor people, not necessarily disadvantaged. And so I just want to be sure that somewhere in those two terms, the domestic well owners in this valley are included in that language, and maybe there's not a problem there.
There are several definitions, unfortunately, multiple definitions of what is known as de minimis. If you take a typical adjudication, 5 acre feet, if you take Sigma, 2 acre feet, and then if you take what is an 850B, they set aside a subset that basically said disadvantaged community members, which they set at a particular financial threshold, and then they said small farmers, which they defined within the statute. There was concern, and we did raise this issue when that statute was being passed, that members such as Mrs. Quist would not fall into the small farmer category and should. However, what the report in 1466 would require is that we report generally on de minimis users. So it would include that. So there's multiple definitions in there.
So you're saying that people like myself who, have a retirement from the Navy and have a shallow well, that I'm not disadvantaged, that I'm not a small farmer, but I am indeed included?
It was included in the report that 1466 requires. What the judge does with that report is still discretionary because the law says the word consider. We would favor expanding that definition, number one, to just be a straight de minimis rather than having all these subset definitions and different definitions. And two, to give the court a menu of options to allow the court to determine how it will consider the rights of a de minimis user, whether that be through class counsel, a report, or other means. We would prefer that rather than to just limit the court to this report. Our opponents object to any ability of a de minimis user or a small farmer or a disadvantaged community member to be represented other than physically within the trial.
Well, I want to thank you guys for looking after us, and I'm hoping when push comes to shove, the hundreds of people like myself who are not necessarily poor, but have shallow wells are included in the definition. And I am neither a small farmer nor poor, like hundreds of people like myself, and I hope that we end up, and I think you're looking out for us, and thank you for that. And I had one other observation. It seems to me, early on, my observation was that an adjudication might be useful to prioritize water rights for the benefit of a groundwater authority to manage the groundwater. Now, I'm very pleased to hear that things are heading in a direction that says that the groundwater, that the studies and models performed by the Groundwater Authority are the ones that matter. And then another question that comes to mind, who will say those things occur, those laws are changed, then will the adjudication judge or will the Groundwater Authority be given the power to manage the basin afterwards? I could imagine a circumstance where maybe the Groundwater Authority model holds, but the judge manages the basin. And it seems to me that maybe, I don't know if there's an uncertainty there in California law, but it would seem to me that it would be proper that the Groundwater Authority be empowered to manage the basin. And thank you all once again for your efforts. It's pretty exciting to see this small community and the people that are so actively and energetically supporting it. This small tail is wagging the dog in the state of California. That wag needs to happen. Thank all you tails for making it happen. That didn't sound right. Thank you, guys.
Thank you, Wes. I think we understood it.
Don Decker. I'm the last standing member of the TAC, I think. One thing that the Water District brings up over and over and over again is the cost of the water. And there's no question that we're headed to higher costs with all kinds of resources that we use, water being the current topic. However, when you look at the situation that we face here with seriously declining water levels virtually everywhere in this basin, when you talk about high cost water, you have to look at the alternative, which is no water for the great majority of people. You know, you're looking here at basically a dying community. That's the alternative to what the Water District needs to get their act together to do. You know, Judy earlier brought up the subject. Had the Water District pursued things back in 1985, we would be in a whole different world here. The California City folks had a very similar basin to our own. It's a closed basin. Their water levels were declining. This is 1970 or so that they realized they had a problem. They got they got their act together, and they were the ones that led to the pipeline from the extreme west side of the AVEC. Thank you, Judy. And they got their act together and found financing and laid a pipe that we're going to take advantage of. And we're bitching here about cost. If we'd done it earlier, it would have been far, far cheaper. But the alternative to high-cost water is minimal water, and I don't think anybody is really interested in that, but that's exactly where that would, refusing to take high-quality water means basically minimal water. Thank you.
Thank you, Don.
George Kroll, General Manager of the Water District. Just wanted to note for the record and to this comment that was just made, I went and talked to Cal City about their water situation. They do have a pipeline that runs out there. They don't use it. They don't buy water from AVEC, and they are formally trying to get out from having to pay AVEC, and they don't even want the water from AVEC. So to the example that was just given, you know, here we have an example where a city paid a significant amount of money to build a pipeline that however many decades later, they don't even want. Thank you very much.
Chairman, yes.
I was gonna say, I think with a few exceptions, there are some differences between California City and Ridgecrest.
Yeah.
But
There are some different exceptions for sure, including the fact that it's in a basin that's not critically overdrafted with wells failing. so it can go onto a well system and not use that pipeline. Which I also want to mention, I don't know that it's true, but I have been told that representatives, let me rephrase that Water District board members are running around in the community saying our pipeline will have to be rebuilt in 30 years. The pipeline is tying into a pipeline that was built in the 70s, and it's working just fine. So I don't know where this 30 years comes from. I'm hearing it third hand, but if the community is hearing that we're going to have to rebuild a pipeline every 30 years, I can assure you that is incorrect, and the facts prove otherwise.
Okay, any other public comment from the floor? We'll move to the phones. Any public comment online? Okay, seeing none. This is a non-action item, so we are complete, and we will move on to item number 11, the Water Resources Manager Report. That will be with Stetson and Steve Johnson.
Correct. Thank you very much, Chairman Heyman, and the board, and all the stakeholders present. That was interesting discussion. I'll just take the opportunity, because it's already a long meeting, but to thank Michael for that presentation. I gotta believe and hope that the stakeholders and everyone listening to this conversation, based on Michael's presentation, found it to be extremely, very, very helpful. So I certainly did, and I'm right in the middle of it, but I found it very, very helpful. For the Water Resource Manager Report, it is written in part of the packet, so everyone has a chance to review it. I'll just hit a few of the high points. We've got some good news, good information. We start with a grant funding update for the implementation grant, Round 1 implementation grant. 2 invoices, 9 and 10, were submitted, covering periods from July to September and October through December. Totaling almost $1.7 million submitted and have been paid. We've received funding for that. Next invoice is invoice 11, due at the end of May of this month, and it'll be ready and it'll be submitted on time. For the Urban Community Drought Relief Program, that's almost $4 million. That's work out on consolidation work. Quick report on Rademacher and on that work. The actual work is underway by the Water District. The actual completion of the pipeline and connection work is not expected to be complete until the Water District has some transmission pipeline system repairs to be made, but they are working on it and it's moving forward. We understand that phase 2 design, which the Water District is working on, is about 90%, so we're in pretty good shape there. So things are moving forward there. We are internally working on the Stark Street Consolidation Feasibility Study to look at connecting multiple residents in the Stark Street area. We're working on that now. For the grant status, same situation. Invoice 3 and invoice 4 for the same period as the invoices above through the end of December 24. For about $27,001 and about $23,000 for the other, so right at $50,000. Invoices submitted and paid, so we are fully up to date with our reimbursement from our grant program, which is good news. There is another grant we are working on. We've periodically reported on the EP, the resilience grant, which is going to supplement the funding we needed to finish the pipeline design and work. Everything we see indicates that we're still in good shape. Our impression was that our application was approved. It was competitive, so it was very, very fortunate that we were approved. However, in working with the EP at the federal government at this point, there has been a new administration. We have been in touch with the grant administrator for EPA for the grant, and there has been a request that we modify some of the application language to make it fall more in line with the current administration in the federal government. We've done that. We've submitted that. We are currently waiting to hear back from that administrator to proceed, but we are still in line to get that grant money, and we obviously we need that money to finish the pipeline design. For the pipeline project, there's updates for the pipeline design services. We're expecting 90% design submittal in June, so it's just a little over a month away, and 100% by the end of December. So we're moving forward. There's multiple technical memorandums that we are currently waiting for from Provost and Pritchard. They're listed in the Water Resource Manager report. Environmental services are proceeding. We've run into multiple pickups in the environmental service related to BLM and right-of-way and surveys that need to be done. We also had some issues with Edison and routes for Edison to provide power that we're working on. Environmental is being affected by that too. So the next milestone from the environmental folks is to provide a environmental assessment and draft EIR, and we're expecting that in the coming months. There's not a date set for that yet. Right-of-way services. We're expected to get a final right-of-way acquisition plan in writing by late this year. Complete plats and legal descriptions, we're expecting those by June, July to review. And then complete appraisals of the parcels that needed to be acquired by the end of this year, 2025. So on the DWR, there's a section in the report regarding DWR submittals. We continue to coordinate with DWR on the IP grant on the progress. We did just get an executed amendment that basically extended the period of time for us to use up the funding that we have remaining, which was approved, and we reallocated some budget. We didn't add, there's no increase to the allocation. We just moved budget items around on task to make sure that it's applied to where we actually need the money. So that's an update on the IP grant with DWR. On pipeline construction, everybody's aware of the WRDA 24 authorization for funding of the pipeline planning. We do have we provided a letter of intent to the Corps working with Michael McKinney's group. That's been done. And through Michael's group, again, we are looking at coordinating a kickoff meeting with Corps of Engineers, Los Angeles Division, to begin work on this project. Shallow well mitigation program, we have no shallow well mitigation applications in our possession right now. So it's we're on hold right now. Not that we don't have shallow well issues out there, but there are no applications that we are currently reviewing. We provide a short section on data collection and monitoring. This is normal procedure. Everything there is normal stuff that we do periodically throughout the year to collect data across the basin. Subflow from Rose Valley, this is the Navy COSO work, the funding for Navy COSO. We still have a monitoring well to drill out there, and we're working on that. Right now, part of the process has taken so long with some of the permitting and some of the issues to get those wells drilled for right-of-way and access that we've run out of time on some of the registration requirements with the Navy, and we are currently working on reactivating that registration. I can just tell you from our staff, there's frustration and trying to work through how you get that SAM, the SAM-6 system reactivated. But we are working on that, and our staff is working with April at the authority staff to get that done. And I think that's it for the Water Resources Manager's report. I'd be happy to answer any questions.
Thank you, Steve. Thanks, Steve. We'll bring back to the board for any questions or comments. Okay, hearing none. Any public comment from the floor? Any public comment on the phones? Okay, seeing none, we will move on to item number 12, which should be the General Manager's report. That will be with Carol.
Hi, thank you, Mr. Chairman. You have in your packet the financial report. These are budget to actuals through March. We're still collecting and processing our financial information for April. So let me know if you have any questions on what you have there. The communications and engagement plan, we're still working with consultant Westbound Communications. They're doing a really good job, but we're getting more information out. And we have resumed work on updating the website. We had done some work internally last year. We've picked up where we left off on the work that was done. Westbound is helping us to give it a facelift, and hopefully we'll be making some good progress on that in the coming months. And then you also have in your packet the monthly report from Capital Core Group. I think Michael has already covered the main topic, but if there are any items in there that you'd like to ask him about, I'm sure he'd be happy to answer those questions. Otherwise, that's all I have for you.
I actually do have an update beyond the other two pieces of legislation that I'll bring to the board's attention. We had heard some rumors in the community that the US EPA grant had been canceled due to DOGE activities, Department of Government Efficiency. That is not the case. The transition, as Steve mentioned, from one administration to another does change priorities, and it is not unusual for us to be delayed while that is going on. We also heard a rumor that it would be harder, or that the appropriations set for the authorization, or that the authorization itself could be canceled by Department of Government Efficiency. That is not the case. A administrative department cannot overrule Congress, and money has been allocated to the U.S. Army Corps of Engineers. It is not for our project in fiscal 25 or in fiscal 26. We are starting authorization or appropriations request for fiscal year 27. Good news is that the United States Senate has begun to hold hearings and oversight on the water provisions of the infrastructure bill. This is the money that goes to the US EPA, US Army Corps of Engineers, and US Bureau of Reclamations for funding the various programs that were in the infrastructure bill. And the president has signaled, and had earlier signaled, that he was in favor of reauthorizing several of these programs. We're in the early stages of that. I would not believe that that will come to pass at any point in time this year. It's probably a next year or even the year beyond. There is a pretty decent up-to-date on the House reconciliation bill, except it does not include the long tax provisions that I know everybody is trying to kind of watch and see what Congress is doing. I will have an update for you on the next one as to what exactly is in the reconciliation bills in the House and the Senate. And then the last thing that I will bring to your attention is I did a fairly decent job of going through the state budget and figuring out how it impacts the various water provisions in the state, whether they be State Water Resources Control Board, Cal EPA, or Department of Water Resources. While we were on this meeting, the governor has released his May revision. I haven't even looked at it at this point. I'll have a report next month on that, but I do urge you to take a look at sort of where the state is going in terms of the water budget actions for this fiscal year. And with that, I'll answer any questions.
Thank you, Mike. Any questions or comments from the board?
Yeah, I actually just had a question in general for Carol. I thought that we were going to have an evaluation on the agenda this time around, but I'm not seeing it on here. Can we make sure that that's on the next agenda, please?
Yes, sir. And we had talked about it internally. We were a little concerned with time restraints for this meeting, but we'll make sure that we have it on for next month.
Okay, thank you.
Any comments from the floor? Okay, any comments on the phone? Seeing none. So I want to thank you, Michael, for the update and for that excellent presentation on AB 1413 and 1466. And we do appreciate you. And so,
thank you.
With that, our next meeting will be on June 11th, and we are adjourned.
Thank you, everyone.
Thank you.